everyone. Welcome to this incredible ERA webinar so that you can find out about all the legal issues surrounding the Equal Rights Amendment. And especially welcome to all the folks who have been listening to the podcast, Ordinary Equality. Hopefully, if you've listened to the podcast, you have a little bit of an idea of all the different issues around the ERA, but we're going to take a deep dive today and we're going to answer all your questions. So if you have any questions in the webinar, you can, there's both questions and then there's also a chat function. So either of those ways you can submit your questions and we'll be answering questions at the end. So let us know if you have any questions. Really quickly, just to introduce myself, my name is Kate Kelly, and I am a human rights attorney. I work at an organization called Equality Now, and that's how you RSVP to the webinar. Equality Now is an organization that specifically works on legal equality. So there's lots of women's rights organizations that do lots of different things and direct services and all kinds of advocacy for women. Equality Now specifically works to change laws that disproportionately impact women and girls. So we work on discriminatory laws. We just issued a great report about Beijing Plus 25 that was about discriminatory laws in every country. Highlights some discriminatory laws in the United States, which there are many, but it gives some examples. And we also work on constitutional reform. So that's the highest level of law in any given country. So that's why we focus on constitutional reform. We'll talk more about this as we go throughout the webinar, but that's why we're involved in the Equal Rights Amendment fight. 85% of countries around the world have a gender provision in their constitutions, and the United States does not. And we can talk a little bit more about why and how we got here and how close we are as we go. Yes, we're so close. So close. We do, so just to give a tiny bit of background before I introduce our incredible speaker today, Linda Coberly. The Equal Rights Amendment was written, it was actually written in 1921, introduced in 1923 into Congress for the first time. It was written by Alice Paul, who was a suffragist. So she worked on getting the 19th Amendment, women's legal right to vote, and then immediately pivoted to the Equal Rights Amendment. So it was introduced in Congress in 1923 every year until 1972. It passed in 1972 in both houses of Congress by an overwhelming majority, and then went to the states. That's what's required under Article 5 of the Constitution. So it passes in Congress, there's nothing, the president has nothing to do with it, and then it goes to the states. This is a procedure that's very clearly outlined, and as we'll talk more, to be left up to the legislative branch. The legislative branch is the one that determines, both the federal and state legislatures are the ones that determine whether or not there'll be an amendment to the Constitution. For the normal amendment process, the courts and the executive branch actually have nothing to do with the amendment process, and that's how the people who framed the U.S. Constitution meant it to be. So in 1972, it went to the states, and immediately all of these states, I think 22 states ratified within that first year. Hawaii ratified on the first day, which is incredible. It was a time gap, so they passed it in the Senate, and then they had, because of the time gap, they had a couple hours more, and then they ratified it that same day in Hawaii, which is really exciting. So the amendment process went through the 1970s and slowed down. It got to the harder states, and there was a really big movement that kind of picked up and led by a woman named Phyllis Schlafly to oppose the Equal Rights Amendment. There's a new TV series coming out about her next week called Mrs. America on Hulu, which is exciting. All the ERA nerds are just excited to see what it's going to be. And so Phyllis Schlafly and her movement slowed the progress of the ERA to ratifications down to the point where towards the end of the 1970s, they came to a halt. There was a deadline attached to the original passage of the ERA, and that was set to expire in 1979. Congress acted in 1978, so before it expired, they extended the deadline from 1979 to 1982. That gave it a 10-year total window for ratification. Unfortunately, in 1982, Between 1978 and 1982, no additional states ratified. So again, we're down to the harder states. You're getting a lot of really culture war type arguments. You're getting anti-ERA women dressed in army fatigues, drenched in blood at protests, using really violent language and really scaring people into opposing the Equal Rights Amendment. Of course, they were the face of the anti-ERA movement, and the people who voted against it were men, because in the legislatures at the time, as today, the vast majority of legislators are men. So we get to the 1982 and we fall 3 states short. We are so close to that finish line, to changing the Constitution. The women's movement, it has been working so hard. You have hundreds of thousands of people marching. You have this huge nationwide cohesive movement to change the Constitution. When we reach that deadline, that movement sort of dissipated and went in different directions. So there were some who focused on getting a de facto ERA in the courts. There are some who focused on legislation and getting all this different piecemeal legislation that has helped women. We have Title IX, we have Title VII, we have Title X, all these different laws. We have the Violence Against Women Act, to sort of kind of piece together some of these protections that we missed out on by not having the ERA. Fast forward, and we can talk a lot more about this, or you can listen to a very excellent podcast about the history of the ERA. But fast forward, what happened after Trump's election in 2017, a lot of folks who never gave up on the ERA had really been peddling it, had really been trying to get momentum, had been going state by state to all the 15 unratified states. They pressed a legislator in Nevada. So they met with a woman named Pat Spearman. She's a senator. She's this incredible queer Black preacher in Nevada. And they said, Pat, will you run the Equal Rights Ratification Bill? And she said, like most Americans, don't we already have that? Didn't that already happen? It hadn't. So Pat got it ratified in 2017. Another state, Illinois, followed in 2018, and that's where Linda comes in. And then 2020, just this year, Virginia ratified in January. So the 38th state, the one that we were, missing in the 1970s, those 3 states that we fell short on, we got. We've now met the threshold in the Constitution. And so now I want to introduce our incredible guest, Linda. I feel like a lot of people in the young people in the ERA movement call me their ERA mom. I feel like you're kind of my ERA mom. There are so many people working on the ERA, but Linda is one of the attorneys that's most dedicated. She is a partner at Winston, Strawn, a law firm, and she's based out of their office in Chicago. Linda got involved when I said Illinois was one of those states that started to ratify. Can you tell us a little bit of your story and how you got engaged?
Absolutely. So I would love to say I've been working on this for decades, and there are a lot of people out there who've been working on this for decades, and that does not include me. I was not in this fight, in the 70s or 80s. I was a kid in the 70s, and I wasn't paying a lot of attention to any of this happening. I got involved in 2017, and it was right after Nevada ratified. And actually, it's the way I got involved is actually through my law firm. The chairman of our firm was listening to NPR on the way into the office one day, and he heard a story on NPR about Pat Spearman and the Nevada effort to ratify the ERA. And he called me to his office, and which he does sometimes. I run our Chicago office, and there's often something for us to talk about. But he called me to his office, and he said, "This is really important. We need to talk about the Equal Rights Amendment." And I was a little shocked. It was not what I was expecting to be on the agenda for the meeting that day. But he said, this is really important. It's consistent with the work we are doing as a firm on equity, and we really should get involved. And I could not have been more excited about that. So we did. We got a group of lawyers together who span all of our offices. We have offices around the country, and we had lots of different people working on it. We started holding events. We hosted a film screening for people here in Chicago. And we also got, we helped to get organized many of the advocates who were working on the ERA in Illinois. And again, they've been working on it for a long time. Some of the people in this movement, as you know, have been working on this since the 70s. And obviously we were new to it, but we felt like we as a law firm had something to contribute, because it's really a law thing that we're doing here, right? Amending the Constitution is a law thing. And there's a lot we can offer in terms of, as lawyers, in terms of explaining how this works and explaining what the impacts would be. We also just help to organize things. So we actually hosted a meeting in 2018 of advocates in our Chicago office on MLK Day. And it was in the afternoon of Martin Luther King Jr. Day. And the idea was just to learn from the different organizations about what they were doing and do what we could do to help get them organized. And after that, we did some writing. We hosted a webinar that had legislators on it, where we were trying to educate about the Equal Rights Amendment. We did analysis. We printed materials. We wrote materials. I testified in the Illinois legislative hearing. And we also got our employees involved. Actually, the more I talked about this within our organization, the more people were excited about it. So we actually circulated a link where people within the state who are voters in the state could submit witness slips and as their own kind of advocacy as taxpayers and voters in the state of Illinois. And it was incredibly exciting when the state of Illinois went ahead and ratified in 2018. It was one of the highlights of my career as a lawyer, was being involved in that effort and seeing it really come to fruition. It was really exciting.
Amazing. I came to this also later. In 1982, I was 2 years old. So I was not involved in the original ERA fight myself, but I find it as an attorney to be one of the most exciting things that we could possibly be working on. Like you
Absolutely.
said, it is so fundamentally a law thing. Like, we are changing the Constitution. And so I'm always surprised when more lawyers are not engaged and not involved or don't even know about it. And a lot of lawyers I talk to, they're like, oh, even we met some folks at a firm who are helping with an amicus brief, and one of the partners came in and he said, but do we really even need this? Aren't women already equal in the law? And I was like,
yep.
I very diplomatically said, like, wouldn't that be nice? Because
it's amazing to me how many people think that the ERA is already in the Constitution, including lawyers. They remember it as something that happened in their childhood or something that they've read about kind of as a cultural phenomenon in the 70s or 80s, and they think it actually happened when it didn't quite happen. There were folks in Illinois who are part of the legislature today who were part of the legislature in 1982 and remember how controversial it was. And so that was a painful chapter for Illinois. And it was particularly poignant for us to be able to bring Illinois to ratification when Illinois was the state where the ERA ended in 1982. It was where Phyllis Schlafly's anti-ERA movement really reached a fever pitch, and it was a very emotional fight, and there were people chained to the door of the Illinois Senate, and it was very emotional and very painful. And that's where it ended for a long, long time. So there have been people over the years, as you mentioned, every single year for decades now, there have been legislators proposing the Equal Rights Amendment anew. Carolyn Maloney, a congresswoman from New York, she's been an advocate for the ERA for years and years, and she has been proposing for years that a new ERA that would start the conversation over. And what's different this year, and just to take the conversation to the legislative fight, what's different this year is that there's a bill now passed in the House and pending in the Senate that would actually remove the time limit that was placed on the ERA from 1972 and continue the ratification process for that version of the ERA. So that's a new development just in the last couple of years. And it's an exciting one, and it's one that presents some really interesting legal questions, but I think really strong arguments for why it should be effective and why we can remove the deadline at this point.
So the good news is we don't have to start over, is what you're saying.
We don't. We don't have to start over.
I think before we get to the sort of contemporary legal issues, I did want to just touch on the reason, like we were talking about, a lot of people go to law school and they take con law, or they've heard about the Constitution even if they haven't been to law school, but they don't quite get why we still, legally speaking, why we still need the ERA. So they might say, like, but we have the 14th Amendment. What about RBG? What did she do in the 1970s? So can you take us through briefly what, legally speaking, like, why aren't we already in the Constitution? Why didn't what RBG did work? And why we still need the ERA?
Well, so what the ERA would do is it would bar discrimination on the basis of sex. So it doesn't use the word women or woman or female. It just eliminates any distinctions based on sex unless there's a very significant and compelling reason for doing a distinction like that. So right now the Constitution doesn't have anything like that. And that was not an accident. When the Constitution was originally drafted and proposed and amended and put in place, it specifically excluded women. In fact, back at that time, of course, women didn't have the rights that we have now, and it was not obvious that women should have the rights that we have now. Women couldn't own property. There were lots of fundamental inequalities. And even at the time of the Civil War, when the Civil War amendments were put in the Constitution, and that's the 13th, 14th, and 15th Amendments, there was a conversation at that time about whether women should be included, and they were not. And of course, we all know that women didn't even get the right to vote until the beginning of the 20th century. So this was not an accident that the Constitution did not guarantee equal rights for men and women, and doesn't today. There have been lots of advances in the law since the early 1970s, right? And because the ERA was proposed to the states for ratification at a time when the women's movement was still kind of very new. There was still, it was the early 1970s. There was still a big fight about, frankly, whether women should be in the workplace and what that would do to the family. And it was a lot of those kinds of issues that Phyllis Schlafly really was able to mobilize people around. It was a fear of feminism and a fear of working women and what it would mean if women had equality. Since then, there's been a lot of changes in the laws. As you pointed out, we now have more rights in terms of protection from discrimination in employment and discrimination in education. Some of the laws that existed at that time have been changed. So, for example, in the 70s, there were laws that distinguished between men and women for purposes of rights after divorce or child rearing. There was a default that the mom got custody after a divorce. Now our laws generally look to the best interest of the child, which is clearly better, right? But we still don't have a basic promise in the Constitution that men and women will be treated equally. And now, Ruth Bader Ginsburg, when she was a lawyer, a practicing lawyer, her work as an advocate was very much focused on building an equality guarantee into the 14th Amendment. The 14th Amendment is the amendment enacted after the Civil War that made it a requirement to give everyone equal protection under the law. And so and it was designed to eliminate discrimination on the basis of race and national origin. So Ruth Bader Ginsburg thought we can use that language to encompass discrimination on the basis of sex. And she was partly successful. So there's a line of cases in the Supreme Court that recognize that the 14th Amendment Equal Protection Clause does provide some protection against discrimination on the basis of sex, but not as much protection as it provides against discrimination on the basis of race. And so that's where we are today in the cases. There is still no guarantee in the Constitution that prohibits discrimination on the basis of sex. And there was a famous interview with Justice Scalia done once he said, the question is not whether the Constitution requires discrimination on the basis of sex. It doesn't. The question is whether it prohibits the discrimination on the basis of sex. It doesn't do that either. And that's because he believed that what was most important was the actual words that were in the Constitution. And there's no question that the 14th Amendment doesn't talk about discrimination on the basis of sex. So if you're Justice Scalia or another justice who really thinks that the text is the most important thing, you're looking in the 14th Amendment and you don't see sex.
Nope.
So you still need it.
And to be fair, the 14th Amendment, that's not what it was envisioned to be.
Correct, it wasn't.
As you pointed out, it was designed to eliminate race discrimination.
It was
when it was originally written. We already have so many questions, so I'm so excited. What? Sorry.
Oh, good.
Yeah, we are like, people are like ERA nerds like crazy. This is amazing. I love you all. So we got a question from Alex, and it says it's topical to what you're talking about. He says, what impact will the ERA have on the 14th Amendment due process clause, perhaps more specifically on intermediate scrutiny in abortion restriction and access cases? With the ERA in place, would those cases need to be analyzed under strict scrutiny? So I'm kind of talking about the main talking point of all the anti-ERA people in all the world. Not that you are, Alex, but I'm saying all these people, it's like they call it the everything related to abortion amendment. That's all they talk about. So I guess let's talk about the elephant in the room. How will this impact abortion, and does that have anything to do with the 14th Amendment?
Well, so a couple of things. There's a lot packed in there. I do think so currently under the cases we have under the 14th Amendment draw a distinction, as you say, between strict scrutiny, intermediate scrutiny, and what's called rational basis review. And just to explain for the non-lawyers in the room what that means, strict scrutiny is the most stringent kind of analysis, and it's the highest level of scrutiny, and that's what applies to currently to discrimination on the basis of race. So if there's a law that discriminates on the basis of race, that law can be justified only if there's a compelling state interest, and that's really the only way that this distinction on the basis of race is really the only way to address the problem that the government has a compelling interest in solving. Then there's rational basis scrutiny at the other end of the spectrum, which applies to all kinds of laws, whether or not they discriminate on the basis of anybody. You know, if it's not a special group that's entitled to special protection, then a law gets rational basis review, which is the lowest level of review. It doesn't mean nothing, but it's much harder to challenge a law under that standard. Gender or sex is a distinction that that the more recent cases in the Supreme Court have put into an intermediate category, intermediate scrutiny. Sex is the only thing at that level of scrutiny, and it's not clear what it means. There have been some cases, in fact, the case involving the Virginia Military Institute, the VMI case, which Justice Ginsburg authored, that was a case that was decided under intermediate scrutiny, but it was pretty tough. It was pretty tough scrutiny, and it held that VMI couldn't discriminate on the basis of sex. So that's the current regime we have with those three different levels. Yeah. If we kept that regime, and there are lots of people who think we shouldn't, but if we kept that regime, having the ERA enacted would bring sex discrimination up to strict scrutiny. It would be the same as discrimination on the basis of sex, and a law would have to meet that same standard in order to be justified. So what impact would this have on abortion? Well, that's a really good question.
It's important to point out that is a very confusing system. And yes. We went to law school, we took constitutional law. A lot of lawyers still don't have any idea what those levels mean. And they're like, what's rational basis again? This is hard for lawyers to explain because it's opaque. It's a sort of haphazard, randomly thrown together with cases over time. This is it. If you're having a hard time understanding the difference between strict scrutiny and intermediate scrutiny, welcome to everyone. It's not that lawyers, really even understand hard fast what the differences are. So it is difficult to understand. It's a hard concept to get across. So again, like just think of it as like highest, intermediate, and lowest, and women don't get the highest. That's the problem. Women don't get the highest.
And here's the other thing. I mean, I've always said that if the political case for the ERA depended on the difference between intermediate scrutiny and strict scrutiny, well, we need a new talking point, because nobody can even articulate what that difference is, much less convince everybody to vote for it. So
explain it to you, and it's hard. Yeah,
that's a pretty tough issue. But what's important, I think, is that there are many justices, including Justice Scalia, who didn't think there should be a thing called intermediate scrutiny, and didn't think that that discrimination on the basis of sex should be encompassed by the 14th Amendment at all, because there's no question that when the 14th Amendment was ratified, people didn't think that's what they were doing. At that time, of course, women still didn't have the right to vote. Certainly, there was no understanding at that time that if we passed this amendment, we're giving men and women equal rights. Nobody thought that. And that's why somebody like Justice Scalia says, and it's not crazy to say this, that that's not what the 14th Amendment should mean, because that's not what people thought they were doing when they enacted it.
Well, and women tried to get the vote through the 14th Amendment, and it didn't work. They still needed an additional amendment. They still needed 19 comes after 14. So we still needed the 19th Amendment to even get the right to vote. So that shows you how little power the 14th Amendment had to prohibit discrimination on the basis of sex at the time. We couldn't, there were cases, and they lost those cases to even get the right to vote under the 14th Amendment. Anyway, we could talk about that all day. What does it have to do with abortion?
So, well, and this is a really good question, and a lot of people have talked about this. So a lot of people say, as Kate mentioned, the ERA is everything related to abortion. That's ERA, everything related to abortion. Of course, the ERA doesn't say anything specifically about abortion at all. It talks only about discrimination on the basis of sex. So you could argue that if the ERA were ratified, that certain laws would be challenged because they amount to discrimination on the basis of sex. And a court would have to listen to that argument and think about it and make a decision based on it. And that's the case with any constitutional amendment. Constitutional amendments are general principles, are general guarantees. They're not specific, and they're meant to be not specific. And that's why your Constitution can literally fit in your pocket. And the US code, the statutes that Congress passes, requires an entire library to house. So there's a reason why those two things are different, and the Constitution is meant to be a statement of general principles that courts then have to interpret. Are people going to argue that an ERA would create additional rights in respect to reproduction? Absolutely, people will argue that, and then other people will argue against that. And I think what's important to remember is that today, we have cases that recognize constitutional rights that relate to abortion, and those cases were decided in ways that have nothing to do with the Equal Rights Amendment. They have to do with a privacy rationale. It has nothing to do with this, and that is the law today, whether or not we have an Equal Rights Amendment. I haven't heard any convincing explanation for what law is there that is okay under Roe v. Wade, or is not okay under Roe v. Wade, but would be okay under the Equal Rights Amendment, or vice versa, right? So I'm not convinced that the ERA will have a dramatic impact on abortion at all. One thing that you can point to is a lot of states, more than half the states now, have their own versions of an Equal Rights Amendment, and there have been a couple of abortion-related decisions under those state ERAs. None of them have struck down all abortion restrictions, which is one of the big talking points you hear from an ERA opponent.
They love it.
None of them have struck down all restrictions. A couple of them have said that a state can't agree to fund certain male-only medical procedures and refuse to fund abortion. So that is the narrow consequence in which the state ERAs have actually been held to have an impact.
If you cover healthcare, you cover healthcare.
If you cover healthcare, right, and you can't have a sex-based distinction for covering healthcare and not covering.
Yeah. I think also it's important. So I think just to summarize what you've said, we have the right currently, we have the constitutional right to access abortion care. That exists. It exists under Roe versus Wade. And in 1973, when Roe versus Wade was decided, they did not have an equal rights amendment. In fact, not very many states had even ratified it at that point. And so the Equal Rights Amendment was very much in play, but that was decided totally separately and apart from the question of an equality provision in the Constitution. Another thing that I think is important to point out is really what the anti-choice movement wants is to take that right away. So there can be restrictions on all rights, like think of the First Amendment. You know, free speech is not completely unfettered. It can be restricted in certain situations.
Right.
You know, the Second Amendment, et cetera. There are, you know, there are gun control laws. Those exist. Those are not against the Second Amendment. Those rights can be restricted. So for them to disingenuously say, you know, it's going to be abortion on demand for any reason, that's not true. There are restrictions, like you said, even with states with the state ERAs, there can be restrictions if they make sense and the government can prove that the laws they've passed make sense and are designed to, you know, protect public health, et cetera. They can have reasons. If they have a good reason and they can prove that's why they passed the law, great, you can keep those restrictions. And that will always continue and that will exist even with the Equal Rights Amendment. What they want is to take away rights that we already have. And so they're worried that they will, you know, impede them from taking away constitutional rights. And I think, you know, it's important to actually get at that motive. So anyways, we could talk about abortion for a long time. Another really good question we got is, could gender fluidity and gender identification, kind of this new idea of gender concept that didn't exist certainly in 1923 and probably not in 1972. The way that people think about gender now, this question is, sorry, this is from, I think, Karen. Could new fluidity of gender identification affect the potential ratification of the ERA? So can you kind of talk about that, you know, what it says in the amendment and who that might apply to?
Well, so what the amendment says is discrimination on the basis of sex. And it uses the word sex. And so it's interesting because this is a situation where probably that meant something different in 1972 than what it means today, right? Today we have a much more fluid understanding of gender and its relationship to biological sex. And that's something that's definitely changed. It's also something that affects other areas of the law too. There's actually a case pending in the US Supreme Court right now that will be decided probably by the end of June that deals with, who knows, that deals with the question whether discrimination on the basis of trans status is discrimination on the basis of sex for purposes of federal statutes. That type of decision could impact how you would read the ERA. It also might not. It depends on what the reasoning of the court is when it decides that question. And we don't know how it's going to come out. The conclusion could be reached. I think a very sensible argument is that discrimination on the basis of trans status or on the basis of the sex of the person to whom you are attracted, all of those things in some way touch on sex and are discrimination on the basis of sex. I think that's a very good argument, and that's the argument that the parties made in this case that's pending in the Supreme Court right now.
So could there be true that once, I mean, as a queer person myself, this is like a very important issue, and I know a lot of younger people care about this a lot. Will it protect trans people? Will it protect discrimination, sexual orientation discrimination? You know, we're talking about, you know, we're talking about a law right now to legislate that, but like, what about constitutional protection for queer people? So I argue that also the reverse could be true. I'm just interested to see what you would think. Like, okay, let's say they decide this in June, and like we get the ERA, and I'll be optimistic. I'll say like next year we get the ERA. JK guys, that it won't happen that quickly. Also, it has a 2-year enactment clause. I know what I'm talking about, but I'm just talking about crystal ball here. If we got the ERA next year and they had already decided that case and another case comes up, could the reverse be true, that the ERA would also impact the way that those cases would be interpreted?
Possibly. Again, it depends on how that case that's before the court right now is decided. One interesting thing about this is that if you look at the history behind those statutes, many, though some of those statutes at least date back several decades to a time when people weren't really talking about this very much. The ERA is a little bit different. And in the legislative hearing where the House voted to lift the deadline on the ERA, and we should get to that issue eventually. In that hearing, Jerry Nadler, the chair of the House Judiciary Committee, made a very clear statement in the record saying he understands that the ERA does apply to bar discrimination on the basis of trans status, gender fluidity, various things. And I think that's important. That's a significant difference potentially between the ERA and one of these statutes. Here's another thing though. In terms of who the ERA protects, it's important to say that the ERA protects everybody. It doesn't just protect women. It protects women, men, queer people, gender fluid people, trans people. And one way to think about that is, suppose that there was a state that had a law that discriminated against women, and that law had a negative impact on a trans woman. That woman could still bring a case to challenge that law. It's the discrimination, it's the sex distinction in the law that matters, not so much the sex of the person who's bringing the lawsuit. So a person who's trans would be able to invoke the ERA to, now the harder question, and the question that the Supreme Court is deciding right now, is whether discrimination on the basis of being trans is something that is discrimination on the basis of sex. I think it is, and Jerry Nadler thought it is, and I think you think it is. So the question is what the courts will say, and that's an issue that's going to have to be litigated when the ERA is in place.
If anyone wants to know more about this, I wrote an article called "The ERA is Queer" in the Advocate, so check that out. Okay, so getting to our modern outstanding legal issues, we had a question from someone who I think kind of steers us in that direction. She says, is there a constitutional time limit on ratification of an amendment in the ERA? A constitutional time limit. So I'll lead Linda into our sort of where we are legally in our court battles and where we are in Congress. But the answer is no, there is no constitutional time limit on ratification. If you read Article 5 of the Constitution, like there are lots of other time limits in the Constitution, which I find interesting. Like that you have 10 years for the census, you have 2 years for representatives, you have, there are time limits in it. So it's not like they think to put those in, but they did not put a time limit in Article 5 for amending the Constitution. So it's not in the Constitution. In fact, there were no time limits, there were no deadlines on any amendments until Prohibition. So they stuck a deadline in for Prohibition. Actually, they thought it would be a poison pill. They wanted to pass Prohibition because it was so popular, but they didn't actually want it to get ratified. So they stuck in a 7-year deadline to Prohibition, and it actually got ratified in a year. So it did not work. But then this time, yeah, that really did not work. That was a constitutional snafu. That didn't work. And so but every amendment after that, except for the 19th Amendment, had a deadline, this 7-year deadline attached to it. So that's where we get the 7 years. That became customary, but it is not in the Constitution. And this is where we bring ourselves today. As Linda was saying earlier, she was part of the ratification effort in Illinois. The attorneys general of Nevada, Illinois, and Virginia have now filed a lawsuit And if you listen to the last episode of Ordinary Equality, the podcast, we heard from Mark Herring, who's the Attorney General of Virginia, about that lawsuit. So can you tell us a little bit about that lawsuit and kind of what the ERA Coalition is doing and this task force that you're involved in?
Absolutely. So the lawsuit is, first of all, every lawsuit's got to have someone who's suing and someone who's being sued, the plaintiff and the defendant. The defendant in this lawsuit is a person who I'm sure was not used to being such a big celebrity, and that is the National Archivist, the archivist of the National Archives. Why, you might wonder? Well, the archivist is the person who has the power under US statutes and the responsibility to actually certify when a constitutional amendment has been fully ratified. This isn't really a constitutional requirement. The only thing that's required in the Constitution is that Congress proposes an amendment to be ratified by the states, and then 3/4 of the states have to ratify it. So that's the only requirement in the Constitution. But Congress enacted a statute, just to be clear about how this was going to work, that said that the National Archivist is the one who you're supposed to send your ratification to. So the state of Illinois, after the legislature ratified, the clerk of the state of Illinois General Assembly sent a document to the archivist saying, just so you know, we've ratified. And the archivist receives that mail and then just keeps track of who has sent them in. And eventually, when 3/4 of the states have ratified, is supposed to issue a certification saying, I have 3/4 of the states, it's now part of the Constitution. And then they can print it and put it in your pocket Constitution. So this is a statutory requirement that the archivist actually go ahead and certify. The archivist today, when it became clear that we were on the verge of the 38th state,
he's basically like, I'm just a dude with a library science degree. I don't want to be in the middle of all this.
Right. So the archivist asked the Department of Justice what he was supposed to do. And the Department of Justice Office of Legal Counsel issued an opinion saying, we don't think you have to ratify. And the reason, or we don't think you have to certify. And the reason we think you don't have to certify is because of this deadline or time limit that exists in the preamble to the Equal Rights Amendment. I'll come back to that in a second because it really matters a lot. I'm sorry?
Can you tell us what the OLC is?
Sure. The Office of Legal Counsel. It's also known as the OLC, and it's basically an office within the Department of Justice that answers hard legal questions. It's
so
an advice. They're Trump's
lawyers, basically. They represent the administration.
Basically, they represent the administration, and the administration actually doesn't have anything to do with this process at all. There's nothing in the Constitution that says the president or the administration has any role to play. But the archivist is represented in lawsuits by the Department of Justice in this kind of lawsuit. And so for the archivist, he's looking at his lawyers, basically, at his lawyers and saying, please help me figure out what to do. And the Office of Legal Counsel said, we don't think you have to certify because of this deadline that exists. And so the archivist issued a press release saying, I've been told I shouldn't certify, so I'm not going to. So doesn't matter what happens, I'm not going to certify unless a court, which frankly was a helpful thing for him to do, because he was making clear that he needs a court to act or else he's not going to certify. And what that did in effect was create a ripe dispute, a ripe lawsuit that the attorneys general of Illinois, Nevada, and Virginia were able to then file. So they filed this lawsuit in the federal district court in Washington, D.C., and they sued the archivist. And the relief they're seeking in the lawsuit is an order by the court ordering the lawsuit to comply, the archivist to comply with the law and certify the amendment as valid. And along the way to getting that relief, the idea is that we will get a court ruling on the question whether this time limit really has an effect on stopping an amendment that is otherwise duly ratified under the Constitution. So the argument in the lawsuit right now is that the the deadline doesn't really have any effect because it can't change the basic Constitution, which have nothing to do with time limits. So under Article 5 of the Constitution, it says that an amendment is valid when ratified by 3/4 of the states, and period. And that has now happened. The amendment has been ratified by 3/4 of the states. So the law claims that the ERA is already valid.
So we got the 3 additional states, and they're saying like our ratifications are valid, the deadline is dumb, like and doesn't count, and the archivist should. They're actually saying the ERA exists already, like it is part
That's
of the
the theory lawsuit. It is already in effect.
Yeah. So we have a question from someone else that takes us to the second outstanding legal issue, and they ask, what about state ratifications? Is there any time limit on that? And I think that kind of takes us to the rescissions issue. So can you explain a little bit more about rescission?
Sure. So there's really, as Kate said, there's really two issues. The first is, what is this deadline and can it really have an effect? And the fact is, no deadline's ever been tested in the courts. There have been some cases that have mentioned deadlines, but there's no case on the books today that deals with the situation where a deadline actually made a difference. Actually, the big case that people always talk about in the Supreme Court about deadlines was one from the run shortly after Prohibition, when somebody said, you should let me out of prison for bootlegging because the Prohibition Amendment was invalid since it contained this deadline. And the Supreme Court said, yeah, no, you were pretty much convicted, and so we're not going to let you out of prison. So that's really the case we have that deals with time limits. So there's that question of, can a time limit that is attached? It's also not in the text of the amendment itself. It's only in the preamble. Can an amendment like that or a time limit like that really stand in the way of an amendment? So that's the first legal question. The second legal question has to do with the 5 states, Nebraska, Tennessee, Idaho, Kentucky, and South Dakota, which voted in the 1970s to either take back or limit their own ratifications. So these are all
ratified when it was really popular in the beginning of the 1970s. They're like, everyone's ratifying, it's a party, we believe in women's rights. And then it got to the end of the 1970s and they're like, wait a minute, abortion, Phyllis Schlafly, women being drafted into the military, like, so they got scared off by those arguments, by the movement, and they tried to take back what they had already done.
Exactly. And on this issue, there's some really good historical precedent that says that once a state ratifies, it can't take that ratification back. And the best historical precedent is actually in the Reconstruction Amendments, the 14th Amendment itself. When the 14th Amendment became part of the Constitution, one of the states, one or two of the states that had actually ratified the 14th Amendment had already tried to take back their ratifications, and yet all 3 branches of the federal government recognized the 14th Amendment as legitimately part of the Constitution. So that's an important historical precedent for the idea that you can't take back a ratification.
So next to Ohio and New Jersey, you can't take it back. The 14th Amendment counts. You're in the list. Exactly. So we're saying now, basically, in answer to her question, there is no, once you, I've heard people describe it as a ratification as a one-time event. Once you ratify, it's ratified. There's no take backs. There's no, like we've seen in the
time limits. You don't have to keep it. It's not like one of those kinds of laws where you have to renew it periodically. The question under the Constitution is just whether the state legislature voted to ratify, yes or no. It either happened or it didn't happen. And once it's happened, you can't take it back. So that's the issue. Now, South Dakota was a little bit different. It just said, basically, we're going to say our ratification is only good until a certain point in time. But again, the Article 5 doesn't really allow for that possibility. Article 5 just asks whether the state's ratified or not. And if it's ratified, that state is done and it counts, and move on to the next.
Goodbye. So under this theory, which I think again has very strong legal backing, we're at the 38. We're done. One of the lawsuit that you mentioned is kind of trying to get at the deadline issue, and we got another question from a woman named Amy. Like, the people on these questions are just like ERA nerds, and they're amazing. So someone is asking, if the Senate doesn't vote on SJ Res 6 this year, can Congress bless the ERA ratification in 2021? Does the vote by Congress need to be contemporaneous with Virginia, as it was with the Madison Amendment? So she's basically asking, like, what's happening in Congress, and if we don't get it ratified in the Senate this year, which we probably won't, because nothing is happening in the Senate. They're calling it a graveyard. Like, it's where all the bills in the House go to die, not just the ERA, all the bills. So she's saying, like, if we don't get SJ Res 6 voted on this year in the Senate, what happens?
So then I think the next Congress would have to take it up. And as a matter of Congress's own rules, that means the House would have to vote again too. Just because that's the way legislation works in the House and the Senate. And so we would have to start that deadline removal process again with the next Congress, but there's no reason to think that would not succeed. The bill passed in the House by a comfortable margin. You never know what's going to happen in November, but there's every reason to think that we may be in a position a year from now to have it passed in both houses of Congress. There's no requirement that the removal of a deadline be contemporaneous with the 38 states ratification. There's no contemporaneity requirement at all here. And in fact, you mentioned the Madison Amendment. That's one of the Madison Amendment is our most recent amendment to the Constitution. It was proposed by James Madison. Yes, that James Madison. And it took 203 years to become part of the Constitution. And it's part of what led people to think maybe we could just finish the ratification of the 1972 ERA rather than just starting over. And it was that Madison Amendment that helped create this concept of finishing the ratification with the earlier amendment.
And if you listen to the podcast, you listen to, I did an interview with Gregory Watson, who is the man who got the 27th Amendment ratified. So go back to the podcast. It's incredible. I love him. I'm obsessed with him. He's my favorite character in American history, because he basically single-handedly got the 27th Amendment ratified because he got a bad grade on a paper about it.
Awesome.
And
I love this.
It's incredible. And then, 40 years later, he went back to the school and had the grade changed. It's incredible, truly. I love him. So we've talked about, just to condense it a bit, we've talked about the deadline. So there are two things that are kind of going on to deal with or eliminate that deadline. One is this lawsuit, which is a really great lawsuit, and it makes sense. It's in DC. It's filed by these 3 states that need their ratifications counted. And then the other way to deal with it is through Congress. And that's actually the way that Article 5 says, that Congress has purview over the amendment process. So the other way, like these incredible legislators like Carolyn Maloney and Jackie Speer and Ben Cardin and Murkowski are trying to just pass an amendment like they did in 1978 to modify the deadline that they originally put in. And then there's this other issue of rescissions, which I think is probably our easiest legal argument. Rescissions don't count. Sorry, it's a one-time thing. And again, we have precedent for that. So we've gotten a couple questions about Mrs. America, because I think people are getting excited and the TV show coming up. So one person asked another question from Karen. She's asked whether we can kind of use Mrs. America to galvanize support for the ERA. And then another person had like a pretty thoughtful question about Mrs. America. She said she's really excited and she's been talking about it on Twitter, but she's gotten some flack from people who are saying that it's anti-feminist. And that, that it's kind of like just another Tiger King. And she thinks, is there negativity associated with Mrs. America warranted? Like, why is there negativity? And she also asked about the question about RBG. So RBG recently said, there's 2 questions. Mrs. America, is it going to be good for the ERA? Are we going to be able to use it? And then the separate question she asked is about RBG. Why did RBG say in a recent interview that she thinks we should start over.
Okay, so I'm going to start with that second question first.
Okay.
Because a lot of people have been talking about that. RBG was asked a question about the ERA and her prognosis for when the ERA will finally be part of the Constitution. And she said, in my view, it should start over because there's so much controversy. It was basically a commentary on the controversy that surrounds the efforts to ratify the 1972 Equal Rights Amendment. And, you know, my view is she was not being asked a constitutional law question. She was being asked a strategy about whether it was a good idea to complete the ratification, or would it be sort of politically better or culturally better or something like that to start over. And, you know, reasonable minds can disagree about that strategy question. I don't think she was forecasting how she would vote on any question that came before the Supreme Court. In fact, she really couldn't have been, because it would be inappropriate for a judge to, they don't do that. They don't do that. It would be wildly inappropriate for a judge to comment publicly on how they're going to rule in a particular case or something like that. So, so I think she was being asked a strategic question, and she answered it. And I'm completely confident that if she were faced with, for example, the question whether it was okay for the Senate and the House in 2021 to vote to remove the deadline that's in the preamble of the ERA, I'm convinced that she would look at that question anew and would regard it, you know, as a clear legal question on a clean slate, et cetera. So I'm confident she would do that. And speaking of articles, I wrote a piece in The Hill about this very thing.
And you're also interviewed
in the Atlantic. Yeah, there's an interview in the Atlantic and an op-ed in The Hill.
Linda is very fancy. I want everyone to know that. And so if you Google her name in ERA, there's lots of things that she's written and been interviewed for. And you did the piece is really good about why the RBG thing was a strategy question. I will also add that Ruth Bader Ginsburg is an appellate lawyer. When she was a lawyer, she was an appellate lawyer. That if you watch the movies about her that have come out recently, you know, she's like, they kind of try to make it cinematic, but like she's doing a lot of research. She's like sitting at a desk, you know, that's what
as appellate lawyer, I can tell you that that's a lot of what I did. Right now I'm sitting in my kitchen, but that's what I do. I sit, I research, I write, I argue.
She does not often sit in her kitchen in non-pandemic times. And do webinars about the ERA. But the point is, RBG was never part of the front lines of getting the Equal Rights Amendment ratified. She was doing a separate strategy of appellate litigation before the Supreme Court, which is a very, very different ballgame. And God bless her, and long may she live. She has never been in some of these states where we are trying to get this thing ratified. You know, Virginia was the most recent state, and that was an absolute battle for years. Like you said, Illinois. Home state of Phyllis Schlafly. You know, people were just absolutely for decades fighting to get the Equal Rights Amendment ratified. And some states are now trying to do this reverse process. So she is opining on something that is really not her lane. Like starting over and getting this ratified in all new 38 states. I'm like, girl, have you ever been to Utah? Have you ever been to Louisiana? Have you ever been to Georgia? Like, I'm not here for trying to start over and do this all over again in these very difficult states. And so I think it's important to keep in mind that she was kind of opining on a strategy question that is not her expertise and not the way that she participated in the original fight. So again, long may she live. God bless her. She's the reason we even have intermediate scrutiny. But I think it's important to keep in mind that this strategy question was something she felt she could talk about because it's not a legal question, like you said.
Exactly.
Okay,
so on the question about Mrs. America, I think the impact of Mrs. So I haven't seen it yet. I'm going to have to get a Hulu subscription and watch it. And I'm excited to watch it. To be honest with you, I kind of hope this is the difference between, you know, kind of a historical piece and policy. Right? Like, I hope that it's actually a good show, in which case it would be kind of even-handed. and it would be multidimensional. And so I actually kind of hope that it doesn't portray Phyllis Schlafly as a completely monodimensional character. And I want to say, I read there was a play that was performed at the Goodman Theater here in Chicago this year called Roe, that told a historical story about the women who were involved in litigating Roe v. Wade. And one of the reasons it was such a brilliant play is because it was not multidimensional, and it left you really feeling for both, you know, the real Jane Roe and Sarah Weddington, and as very multidimensional characters, which I thought was very effective. So I actually expect, given the quality of the actors who are in this show, that it's going to be pretty multidimensional. So I don't know what impact it's going to have on the politics of the ERA. I love that we're talking about it at all. And I think even if you present Phyllis Schlafly in a kind of even-handed light, as I hope she is presented, I think it will be clear to anyone watching that the basic argument she was making in the early 70s and ultimately through the late 70s is one that doesn't make sense today. So, for example, it no longer makes sense to say that that if we have a draft, it should be a male-only draft. That seems like an absurd idea in 2020, when all kinds of women serve in all kinds of capacities with tremendous distinction in the military, including in combat. And so, and Congress could decide today to include women in the draft. And in fact, John McCain wanted to, and the Pentagon recommended that a couple of years ago. So this is, I think that even if it's even-handed, the arguments she made at that time sound very discordant today, because they're just not where our culture is.
And honestly, Phyllis Schlafly, for my podcast, listened to hours and hours of her debates, and she was a genius. Honestly, she was a genius. You look at the debates, she just like wiped the floor with Betty Friedan. She was so quick. She was so well practiced. Her character is a really fascinating one. So I think it's an interesting one that you can portray. Also, Cate Blanchett. How can you argue with Cate Blanchett?
Right.
But like, I think there's an interesting, and I also think it's really important that we take very conservative, very talented conservative women who fight against women's rights seriously. That was part of the problem with the feminists in the 1970s.
Absolutely.
They didn't take her seriously. They were like, she's a housewife. And then she would just like clean the floor with them in debates. They didn't prepare adequately. And she knew that. She anticipated that they would underestimate her. So I think learning about these women is really important, because even today, a lot of the women who argue against the ERA and show up to the hearings and testify against it, it's always women. They never have men go out there and say, like, we don't want women to have equal rights. They push women to the front. That's the strategy.
Absolutely.
It always has been the strategy. And I think for our generation, it's important to learn about that strategy and the way that it worked. So I think it will be good for the movement. I think also a lot of young people will be like, wait, what's this? Like, this didn't happen. So I'm excited about it. I think it will be a way to galvanize. The more the ERA is in pop culture, the more people will know about it. And this ties, and I think, oh wait, what were we gonna say?
Oh, I was just going to say what I think is important for those of us who are advocating for the ERA is to seize the moment, right? There was a documentary that was done on MSNBC that you were on, as I recall, speaking of being fancy, which talked about the old effort to ratify the ERA, but it sort of stopped at a point in time and didn't really get into the contemporary. The producers made the decision to do a pretty comprehensive discussion.
I did talk about that in my interview.
You did, but the producers chose not to focus very much on it in the presentation, which I get. They were doing a historical piece, but then I think it's important for advocates to take the conversation to the next step. And so for all of us in the ERA movement, I think it's going to be important to kind of seize on the Mrs. America moment and say to people, okay, so now you saw that history thing. Okay, so you should know that the ERA is on the cusp of becoming part of the Constitution today, and here's what needs to happen.
And you can be part of that history.
Exactly.
Okay, so we got to wrap up because we told people we would be an hour, and we want to be mindful of people's time. So the last two questions I think kind of tie together and are a way for us to kind of wrap up with some what can people do now. and how can they get involved. So someone asks, David asks, are there any high profile people who are advocating for the ERA, specifically men? So like, what about Obama? What about Biden? Like, why aren't they talking about the ERA? And then Karen asked, is there a single greatest challenge or roadblock to ratification of the ERA? And I'm just gonna opine on that really quick. I think the single greatest challenge to the Equal Rights Amendment is people knowing about it. Like people, 80% of people think it's already in the Constitution, and also women think they already are equal. So actually, educating people to know that they aren't equal when they think they are is like a really tough position to be in. In the 1970s, women were like, I can't get a credit card. I can't I can't get to, I can't get all these things. I'm legally barred. I make so much less than men. I can't even get jobs. Like it was so apparent. And I think younger women are just now waking up to the ways in which we are not treated equally in the workforce, in Congress, in all these different ways. So I think education is the hardest part about our biggest roadblock. Getting the momentum up, getting people to know about it. So if you're on this webinar and you are obviously so engaged and interested in the ERA, I would say tell people about it, share, articles, share Mrs. America, whatever it takes to get people involved and engaged, and use that as a way to tell folks, hey, it's still happening and we can play a part. And then I will also just put in a final plug for the podcast, Ordinary Equality. I think as the host, I think it is a great way, especially to share with younger people, to say like, there's a podcast you can learn from start to finish what the ERA is about and how we can get involved. So I would say just try to raise awareness, and that's my 2 cents for ERA advocacy.
I totally agree. And I'll just wrap up by saying that, by pointing to something else Ruth Bader Ginsburg said in that same interview, which is some people say that at this point in time, the ERA is largely symbolic. And even if that were true, isn't it a really important symbol? And I really feel that way, that even if it were the case that all of these other protections that we've acquired in the last 40 years are really all we need, and I don't think that's true. I think we do need more protections. The fact that there is still such a fight about this tells me that we still need it. Because if it were so obvious that women were equal, there wouldn't be such an opposition to the Equal Rights Amendment, and we could just put it in the answer to that is, so then let's put it in the Constitution if it's so obvious. So if it's a symbol, even if it's a symbol, it's a really important symbol.
When you get to the it's just symbolic argument, it's like, okay, then let's put it in. What's the harm?
Right. Exactly.
So thank you so much for your time. Thank you so much for your advocacy. Winston Strawn has been one of the firms that's the most out there, has been in the fight, promoting the state fights, even when it wasn't nationally known. So I appreciate your boss who heard about it on NPR, a man. There are many men who support ratification of the Equal Rights Amendment. So Linda's boss heard about it on NPR. And got the firm involved. And I think it's incredibly important for people of all genders to get involved. So thank you for what you do. Thank you for Winston Strawn. Thank you for your work on the ERA Coalition.
Thank you so much. Congratulations on your podcast. It's really exciting, and I'm just thrilled to be part of it. Thank you so much, Kate.
Thank you. Bye, everybody.
Bye.
Thanks for joining us.